Welcome to Day and Night Prime Debate. It's a trend. A son of a businessman takes over the business from his father. A bureaucrat's son generally takes on to administrative field. An actor's son to acting, and so on. Similarly, a son or a daughter of a judge is bound to enter the field of law, and they generally practice in courts where their father or relatives do. But does this in a way lead to nepotism and favoritism? Tonight on Prime Debate, we discuss the uncle judges syndrome. The issue of uncle judges is not a new one. There are many instances where judges and their relatives are practicing in the same High Court. This in turn has raised serious questions about integrity of such judges.
Standing by its uncle judges syndrome remarks, the Supreme Court has refused to entertain an Allahabad High Court petition seeking expunction of its controversial remarks. The Supreme Court had earlier remarked that something was rotten in the Allahabad High Court and that it was suffering from the uncle judges syndrome. These unprecedentedly harsh comments of the Supreme Court has again drawn attention to corruption and misconduct among judges of the higher judiciary. Higher courts have criticized lower courts in the past for the judicial failings and lapses, but it is perhaps for the first time that the Supreme Court has criticized a high court for the personal misdemeanor of judges in such strong language. Saying that something is rotten, the court wanted a spring cleaning of the court with the transfer of corrupt judges from there. The uncle judge phenomena is prevalent not only in the Allahabad High Court but elsewhere also. When the court observed that sons or relatives of judges become multi-millionaires within a few years of starting practice, it meant that they made use of their proximity to judges to secure favorable judgments. The judges who helped their relatives to win cases are clearly guilty of nepotism and corruption. When a case is decided not on its merit but on the basis of lawyers' relationship with the judge, justice does take a knock.
To discuss these contentious issues, we have four eminent lawyers: former Senior Standing Counsel for Chandigarh Administration, Anupam Gupta; General Secretary of Lawyers for Human Rights International, Navkiran Singh; Additional Advocate General Punjab, Harpreet Singh Barad; and a retired officer of the Army's Judge Advocate General Branch and now a practicing lawyer, Colonel S.K. Agarwal. Welcome to the discussion. Anupam, the Supreme Court has upheld its earlier very scathing remarks on the Allahabad High Court that the sons and daughters of the judges who are practicing in the same courts are become multimillionaires overnight. Now, this must be prevalent in other courts as well, including the Punjab and Haryana High Court. What is your take?
Well, it is a comprehensive and all-pervasive problem touching almost every high court in the country, including the Punjab and Haryana High Court. In the Punjab and Haryana High Court, it's been a problem as old as about 2 decades. Keeps recurring, especially with the generation change. You have new judges, with old judges retiring, new judges, new relatives. So the problem keeps recurring.
But how come you said 2 decades and nothing has been done all these years?
It was done. In 1993, when Chief Justice Venkatachalaya was the Chief Justice of India, and on an all-India basis, the transfer policy of judges was initiated, a large number of whom were judges whose relatives were practicing the same court. Almost 200 judges were transferred, but thereafter the policy was eroded from within. There was a silent or a tacit resistance to the policy.
But Anupam, tell me, what is the general feeling of the lawyers on this issue?
Well, beginning with the High Court here, there have been 3 transfers, 2 of which are directly relatable to the problem of nepotism. And this has been, my sense of the bar's reaction is, it has been widely welcomed.
Navkiran Singh, all those judges whose relatives are practicing in the same court, there has been a demand from the bar that those judges should be transferred out. Do you support this demand?
Well, I think the problem lies that there's a bigger problem. it's not only that you can end corruption with the transfer of judges. The problem is that there is a character crisis in the nation, and judges are also one of those character crisis problems. So suppose we transfer one judge from another to another high court, there is another judge who is coming to this high court. So if you are trying to save yourself from corrupt judges, that is no solution. I am not opposing the transfer of the judges. I am in favor that a person who is appointed as a judge should serve in any corner of the nation if he is really doing a national duty. But I am saying that the problem will still not be solved, because the problem is somewhere else. We ought to find people who are having a good character, who are above board, and who are not corruptible, and then ensure that wherever they are serving well. So it's a character crisis in the judiciary, in the country as well.
It may be a character crisis, but then you have a bigger problem. But this is definitely a part of the problem, isn't it?
I understand. Some part of the problem can be solved. At least the apprehensions in the mind of the people that the judges who are practicing over here, their relatives can maneuver the law. But I don't think that's going to solve the problem. The problem lies somewhere else, and we need to find a solution for that.
Colonel Agarwal, now you've been in the army and now you are practicing in the High Court. I believe there is a system now that those being elevated to the bench from amongst the lawyers, they have to give an undertaking of sorts that whether their kin and kith are practicing here or not. Do you think that's a good thing, if that practice has been started?
It is a good thing, but we should look at the problem from a wider angle. The problem lies in the very elevation of the advocates to the bench. I am of the firm opinion that we should consider the High Court judges as all India service, and the first two postings should be only outside the state High Court where they are practicing. Because this is a very cancerous disease which is spreading in the judiciary, and as you said earlier, the perception of the people has changed. And the day the perception and the confidence of the people changes anti-judiciary, I think that is the last citadel of our democracy.
I think you touched on a different thing altogether. We could discuss that a little later. Anupam, do we need to change the Bar Council rules as we
You see, the rule relates to an individual judge. It has served the cause well, but here we are dealing with nepotism on an institutional plane, where a court is 50 judges strong, yes, 40 judges strong, 20 judges strong. This rule, of course, would not apply unless a bold and valiant judge like Chief Justice B.K. Roy, who applied this rule in a different context while framing the roster, that judges who have relatives will not hear cases in which their relatives are appearing. That was a sharp extension of Rule 6. But essentially, I think this requires to be handled at the constitutional plane. And I would therefore propose a twofold method of dealing with it. One, an amendment to the Constitution. Now, this touches upon the issue which you put to Mr. Agarwal, that while being appointed, this will apply prospectively.
Yes.
Judges, while being appointed in the first instance, should be appointed only in states where they do not have any relatives practicing. The degree of relatives, the degree of relationships involved could be taken from Rule 6. It could be patterned on Rule 6. Right. It's comprehensive enough. But it cannot, of course, be applied retrospectively. So judges who have already been appointed, there is need to reactivate the transfer policy, and that can be done only by the Chief Justice of India. He has started the process. As I said, 2 out of 3 judges who have been transferred from the High Court are embodiments of this problem.
Right. Anupam, you talked about Justice B.K. Roy's tenure.
Yes.
I think that is then when this issue hit the headlines in Punjab and Haryana High Court. And I remember Justice Roy saying that it is generally believed that A, B, C, D, which is he's referring to the judges, constituted a mutual cooperative society. In the sense, it was believed that each of those 4 judges would protect the sons of the 3 other judges.
These are words
as serious as this?
These are words which he borrowed. He passed a detailed order as the Chief Justice,
yes,
who has the power to frame the roster, which judge shall hear which case or class of cases. He borrowed these words from Mr. H.M. Sirvai, the late Advocate General of Maharashtra, who wrote them down in his famous commentary on the Constitution. There are differences of degree. As a broad principle, it is as serious as this. As a perception of the public at large, and not only the public, as a perception of a large number of lawyers, especially the younger lot of lawyers, this is true. It may not be true to the hilt in each and every case, but as a principle, as a theme, as a concept, is definitely germane.
Navken Singh, before we go into a break, I want to take your opinion on what Anupam has said and also what Justice B.K. Roy said, a mutual cooperative society. That's how he referred to the judges.
You see, firstly, I would like to give a reply to what Harpreet said.
Yes.
I never said that all the judges are corrupt, firstly. Secondly, why I have an opinion that the judges transfers whose relatives are practicing over here would not really solve the problem. I'm not opposing it. I'm saying really solve the problem is because Justice Nirmal Yadav had no relative over here. Now you know very well that people, the Supreme Court who is talking of cleaning the house at Allahabad, they never bothered to even withdraw the work from her. Everybody knows that she took money. A bar association made an application before the special judge wanting to get her prosecuted, but they are really not interested to prosecute her. So why are the things so difficult? It's not only that the relatives who are practicing is the main issue. The issue is corruption.
So coming back to what Justice Roy said, a mutual cooperative society of judges.
That's right. So if a judge is corrupt, you don't need a relative for that. You don't need a relative to be corrupt. You just need an agent.
But the public perception is that, you know, if you have, as the Supreme Court also said, that if you have a judge who is related to you, it is easy for you to get cases and become a multimillionaire, as the Supreme Court said.
Secondly, sir, suppose a judge is practicing in the Supreme Court and his son or son-in-law is practicing in Delhi High Court. What would you do with that? So it's not an issue of transfer. A Supreme Court judge cannot be transferred anywhere. And we know very well that Supreme Court judges have not been also above board. Their wards have been misusing their position. So what to do in that case?
Well, Anupam, I think that's a very interesting point. I mean,
the issue is corruption.
There could be similar instances even at the Supreme Court.
I have spoken on this before, and to that extent, to the extent of involvement of Supreme Court judges and their relatives, I would agree with my dear friend, though not on the other aspects of the matter.
Yes.
The issue of Supreme Court judges and their relatives is a major issue. The non-transferability of the Supreme Court judges and the very nature of things is a major part of the problem, renders it almost irresolvable, and therefore that also, in my humble opinion, but considered opinion, calls for an amendment to the Constitution.
Anupam, a new bill is being brought, Judges Standards and Accountability Bill. Do you think that will make a difference? I mean, the bill does say that the residence of a judge will not be used by the lawyer relatives. The residence of a judge will not be used by the relatives of the judge.
As I read it, this bill does not essentially deal with the problem of nepotism. That's a passing reference in section 3 of the act, of the bill, in the context of a restatement of judicial values. The degrees of relationships given in the explanation to section 3 are broad enough. It's an inclusive definition of relatives. So in place of rule 6 of the Bar Council rules, you can take section 3 if you want to address the issue of nepotism. But unfortunately, that's a major limitation of the act. It deals with corruption and judicial delinquency in a broad general sense, but not with nepotism per se.
Okay. Navken Singh, even the 230th Law Commission in its report in 2009 stated about, it said almost the same thing. It actually indicated that a person who has practiced in a certain bar should not be elevated in the same place. Do you agree?
See, I also agree with that. I also would go a step further. I had taken out ethics of the judges of the various countries, and I have those lying on my table. I personally feel now in the developed nations what they have done is, suppose you are practicing in one law firm, and out of that law firm one of the member becomes a judge. So they have made it as an ethic, legal ethic, that nobody from that law firm will be appearing before that judge for a period of 3 years. Here we have seen, suppose why I was touching that it's not only the relative syndrome. No, we know about a judge who did not have a son or any relative, but the junior who was practicing with him, the very next day when the judge was elevated, the junior who got all the briefs of his started appearing before him. So what do you expect him to do? You see, a junior who is working with you, he starts appearing the very next day with you.
So to that extent, what the Law Commission said is a good thing, that if a person has been practicing in a particular high court, he should not be elevated there.